Straight ahead on Law&Crime Daily, the latest developments in the Sarah Lawrence College sex cult federal trial.
Larry Ray effectively did what prosecutors describe as a long night of torture.
And from the Olympics to an attempted murder trial,
I'm taking my life back.
we take a closer look at the case of Michael Barisone. Plus,
Mr. Ziminiski instructed Mr. Rosenbaum to get him and kill him. That's what I heard.
a key figure in the Kyle Rittenhouse case faces trial in the same courthouse. But first, is a new trial in the cards for convicted killer Scott Peterson? The latest developments out of evidentiary hearings in California. Law&Crime Daily, covering court cases from coast to coast. And welcome everybody to Law&Crime Daily. I'm Jesse Weber in for Brian Buckmeyer. Along with me in New York, as always, is Terry Austin. We begin with news out of California as convicted murderer Scott Peterson's defense team works overtime to score their client a new trial. Evidentiary hearings concluded on Friday for alleged juror misconduct. Now that means that the choice whether Peterson is granted a new trial is now in the hands of a California judge. Defense attorneys for Peterson called a total of 4 witnesses during a series of evidentiary hearings held between late February and Friday of this week. The prosecution didn't call any witnesses. The hearings stem from alleged juror misconduct at the hands of Rochelle Neese, dubbed by the media as Strawberry Shortcake. Now, Neese served as juror number 7 in Peterson's 2004 trial. At the time, Neese indicated she had never been abused while filling out her jury questionnaire, but she later admitted she was involved in multiple domestic disturbance incidents, at least one of which happened when she was pregnant. Defense attorneys say that constitutes juror misconduct and their client should receive a new trial. A series of evidentiary hearings for that motion began in February, where Neese took the stand. She told the judge she filled out the jury forms accurately, saying she never considered herself a victim. She also said she never held the murder against Peterson, but did admit to writing to the defendant after his conviction. In 2004, Peterson was convicted for the 2002 murders of his wife Laci and unborn son Connor. He was sentenced to death, but the California Supreme Court later threw out that ruling, and he was then resentenced to life in prison. Peterson has always maintained his innocence. Well, joining us today, of course, is co-host Terry Austin, but also criminal defense attorney Nicole DeBoard. All right, Nicole, I want to start with you. What do you think the odds are that Peterson's actually going to get a new trial? And if he does, what is that going to look like? What can we expect?
I think that the odds are reasonably high. Jury information like this can be substantial error. You are counting on honest responses from jurors, and it's really difficult to uncover many times in the post-conviction phase that a juror has said something to get onto the jury that is false. But in this case, they've got the information. She's admitted that essentially she was a victim, even though she didn't consider herself one, in several domestic violence cases, even though she didn't disclose that on her jury form, and then ultimately ends up, of course, convicting Peterson. So I think that this is something that the court is going to have to weigh very heavily and very possibly will grant a new trial.
Well, Terry, you know what's interesting is that Rochelle Neese, she received immunity for her testimony. It's not something we haven't seen before. So what could happen to a juror who were to testify without immunity?
You know, if you don't have that immunity, you really can be charged with contempt of court or obstruction of justice. These are the types of jurors, they're called stealth jurors. They're trying to get on that trial. They have a hidden agenda. They want to influence the outcome. And we're beginning to see a lot of this in high-profile cases. We saw it with Ghislaine Maxwell, and these jurors want their 15 minutes of fame. But in my opinion, they really should not get immunity. They should be held in contempt because every defendant has a Sixth Amendment right to a fair trial. And if there's a new trial, it costs a lot of money. So we need to take it seriously. That's absolutely so well said. No matter the defendant, no matter the case, everyone is entitled to a fair trial. And I can't believe Scott Peterson's name is in the news again, but we'll see which way it goes. All right, turning now to news out of New York. The Legal Aid Society filed a class action lawsuit this week pertaining to the New York Police Department taking DNA samples from suspects without a warrant or court order. The Legal Aid Society calls this a rogue DNA database. The lawsuit is filed on behalf of clients Shakira Leslie and Shamil Burgos and others who had had their DNA entered into a suspect index without their consent.
Now, neither Leslie nor Burgos have been convicted of a crime. There are more than 32,000 profiles in the index, with Black and Hispanic populations being the dominant races. The DNA is being collected from the person's cigarette butts and cups of water. Attorneys for legal aid argue a violation has been made both of state law and Fourth Amendment rights, which protect from unreasonable search and seizure. NYPD Sergeant Edward Riley made a statement saying that the department will in fact review the lawsuit. And now an update in a story we first brought to you here on Law and Crime Daily. The California couple charged with the death of their 2 adopted sons are served criminal protective orders in connection with their other children. That means suspects Trezell and Jacqueline West cannot see their 2 biological children and 2 remaining adopted children without supervision and only once per month. This comes just weeks after the Wests were indicted in the deaths of their adopted sons, 3- and 4-year-olds Orrin and Orson West. The boys were reported missing in December 2020, and their bodies have never been found. Prosecutors now say the Wests killed their adoptive sons months before they were reported missing. They now face charges of second-degree murder, cruelty to a child, and false reporting of an emergency. Still ahead on Law and Crime Daily, we take a closer look at the coming trial of Michael Barisone, the one-time Olympian now accused of attempted murder. But first, before Kyle Rittenhouse fired his AR-15, prosecutors say Joseph Ziminski fired a shot in Kenosha, Wisconsin. And Jeanette Levy's here with a look ahead at Ziminski's coming trial.
Hi, this is Dan Abrams with exciting news for all of our Law and Crime followers on YouTube. You can now get the live Law and Crime Network with YouTube TV for all of your daily live trial coverage, legal news, expert analysis, and original true crime programs. Subscribe to YouTube TV today and then locate Law and Crime in the channel guide. And for only $1.99 a month, you can add the network to your bundle. Watch Law and Crime every day with YouTube TV. We put you in the jury box.
Welcome back, everybody. The riots in Kenosha following the police shooting of Jacob Blake in August 2020 created tens of millions of dollars in property damage. And soon the trial will start for a rioter who fired a gun on one of those nights and became a key figure in the trial of Kyle Rittenhouse. Law and Crime's own and Jeanette Levy has more on Joshua Ziminski's case.
Joshua Ziminski faces several charges related to the riots in Kenosha. Prosecutors say he set a dumpster on fire one night and also fired one shot in the air. He's also charged with obstructing an officer. Ziminski can be seen in videos from live streamers who were recording that night. Kyle Rittenhouse's defense claimed at his trial that Joshua Ziminski instigated the confrontation between Rittenhouse and Joseph Rosenbaum. Rosenbaum is the first man that Kyle Rittenhouse shot that night.
Mr. Ziminski instructed Mr. Rosenbaum to get him and kill him. That's what I heard.
Rittenhouse testified he feared for his life and that Rosenbaum chased him, as seen in drone video.
After he throws the bag and he continues to run, he's gaining speed on me. A gunshot is fired from behind me.
Prosecutors say Ziminski fired that one shot in the air seconds before Rittenhouse shot Joseph Rosenbaum 4 times. Neither prosecutors nor the defense attorneys called Joshua Ziminski to testify at Kyle Rittenhouse's trial. But at a recent hearing, Ziminski's lawyer told the court that he would take the stand at trial and claim that Kyle Rittenhouse is the one who started the entire confrontation when he pointed his rifle not only at him, but also Joseph Rosenbaum. For Law and Crime Daily, I'm Jeanette Levy.
All right, so Terry, Nicole, we have a lot to talk about here. Terry, the charges against Ziminski are clearly less serious than the charges that were levied against Rittenhouse. Still, same kind of event, same courthouse. Do you think there's a possibility he's also going to be acquitted?
Jesse, I think there's a very good possibility that he might be acquitted. Listen, the Rittenhouse jury thought that Kyle Rittenhouse had a right to break the curfew. He had a right to defend himself with that weapon. And Ziminski's charged with misdemeanor use of a dangerous weapon because he had that weapon and he shot it in the air. So they thought that was a misdemeanor. But he's also charged with the arson. But I think a jury, at least in Kenosha, Wisconsin, is going to think everyone was breaking the curfew, people were starting fires. Listen, he was out on bond for just $1,000. His wife has already pled guilty to similar charges. She's serving 7 months. I think the prosecution is trying to make a point here, but we'll have to see whether the jury believes that point should be made.
I don't know, Terry. The case of self-defense, this might be a little different, but we'll see. Now, Nicole, what are the odds that Kyle Rittenhouse himself could be called to the stand and testify as a witness in this case?
I think it's entirely possible. His trial is over and he now has no exposure unless they argue that potentially others could be investigating charges, which I really don't see at this point. So he no longer has that right to remain silent, if you will, because his case has concluded. It's entirely possible that they could call him to testify on the one hand. On the other hand, the prosecution really who would be interested in calling him because his side would potentially align more with their side may just be done with Rittenhouse and decide that it's too much risk to call him to the stand at all.
It would be interesting to see. That's the very least. Some great predictions, so we'll see where it ultimately turns up in the Ziminiski case. Coming up on Law&Crime Daily, we're going to head to New York, where the accused Sarah Lawrence College cult leader faces more than a dozen charges in federal court. Plus, a one-time Olympian will soon stand trial for multiple counts of attempted murder. We take a closer look at the charges Michael Barisone now faces. Welcome back to Law&Crime Daily. We look ahead now to a trial out of New Jersey where a one-time Olympian faces multiple counts of attempted murder. It's a trial you can see on the Law&Crime Network live with our gavel-to-gavel coverage. Michael Barisone faces 2 attempted murder charges stemming from the shooting of Lauren Kanarek. This comes as part of an ongoing dispute at Barisone's Long Valley Farm in upstate New Jersey. Now, at the time of the shooting, Barisone was training Kanarek as a dressage rider, but their relationship soon turned sour when she became a tenant on his property. Kanarek lived there with her boyfriend as part of an agreement of using Barisone's farm facilities and training under him. A string of 911 phone calls were placed from both parties leading up to the shooting.
Okay, tell me exactly what happened.
These people are on our place. They have been living in our house in one of the apartment units. They are clients here at our horse stable. This situation is getting worse and worse and worse. The police have been here twice in the last 3 days. They're nuts. They're stalking us. They're harassing us. Last night there was a Facebook post, which is what this woman does. She's
okay. So
anyway, the Facebook post says, "My split personalities are going to take over, and I am not control of what they do. We are in fear for our lives."
Opening statements are expected to be presented in this case next Monday. So, Terry, an attempted murder charge seems kind of hard to prove. What does the prosecution need to bring forward in order to get a conviction here?
Well, like you said, we're in New Jersey, and they define attempted murder as the failure to commit the murder. And what you have to prove, basically, is that the defendant intentionally tried to kill someone else. And basically, they have to show that there was preparation for that act, that there were substantial steps taken towards the act, and then the victim, of course, must not have died. I think in this case, we will see that there were substantial steps taken towards the act. We'll see how and when he got that gun. We'll see the fact that he actually did shoot one of the victims twice in the chest. So I think that those acts were taken towards the attempted murder. I don't think they're going to have a difficult time proving that specific charge, as long as they can put him in that place at that time. So we'll see what happens, but it looks like a strong case to me.
Well, Nicole, let's assume the prosecution can prove the case. What kind of punishment could Barisone ultimately face?
He could face years in prison as a result of, attempted murder, essentially. So, I mean, this is an incredibly serious charge. It's obviously not murder because the people who were involved, even though shot in the chest, survived. So you're left with the next sort of level of reduced charge, which of course is the attempt. And just because the complainant or the victim did not die does not mean that you don't have substantial criminal liability. And that is exactly what Barisone has in this case.
And Terry, you know, we have about 10 seconds. Self-defense, you think that has any play here?
I don't think it's going to have play, but they're going to play those tapes, and I think he's going to say he thought he might have gotten attacked. So he was trying to protect himself, protect his family, protect the farm.
It's an argument. It's just shocking to see where someone started and now where they're ending up so many years later, but it's a trial that we will definitely follow. Well, this week on Prime Crime, it's all about the mysterious disappearance of Victoria Prokopovich. In this strange nobody case, the question becomes, did she vanish on her own, or was she the victim of a murder? The answers may lie in the multiple interviews with her husband, James.
First thing I did, I jumped in the truck. And I rode every road. I went up and down, because she does like to go for a walk.
Jim, why are you so certain that she's not coming back?
I just had that gut feeling, Roman. I don't know.
It doesn't make sense. If she was to run off, she would take some things that are important to her.
She would, yes.
If she was to hurt herself, she has no means of hiding her body.
No.
And you can catch new episodes of Prime Crime every Friday at 5:30 and 10:30 p.m. Eastern here on the Law&Crime Network. When we come back, Law&Crime Network's Adam Klasfeld is inside the courthouse where accused cult leader Lawrence Ray stands trial. The latest developments in the Sarah Lawrence College cult federal trial. After 5 days of testimony on the stand, the prosecution's star witness finishes her testimony in the Sarah Lawrence College cult federal trial. This comes as defendant Lawrence Larry Ray faces 17 federal charges, including racketeering and sex trafficking. The charges stem from allegations that Ray facilitated and led a cult at Sarah Lawrence College dating back to 2010. That's when prosecutors say Ray moved in with his daughter, who was a student at the school. Now, officials say Ray befriended several students and abused them for upwards of 10 years. Prosecutors say he extorted money from the students, forced them into sex and prostitution, and even held manipulative therapy sessions. For days, jurors heard from alleged cult member Claudia Jury, who says she earned more than $2.5 million while acting as a prostitute for Ray. She also told jurors that Ray emotionally abused her and even tried to suffocate her. Now, Law&Crime Network's Adam Klasfeld was at the federal courthouse Friday as Jury concluded her testimony. He joins us with a closer look at the cross-examination and rebuttal of her testimony.
As the testimony concluded, we had cross-examination by Larry Ray's defense attorney, federal defender, who wanted to essentially paint this as a more consensual affair, that she has asked a series of questions pointing to the witness's previously stated views of sex work. There was an exhibit that went into evidence where she apparently said in 2016, sex work is awesome. Asked about that on redirect examination today, she said, well, at the time when she said she was under Larry Ray's spell, that she basically identified herself in two ways in her life. One was the way Larry Ray tried to make her believe that she was someone who poisoned people. We heard this again in testimony over and over again, not only with Claudia Drury, but with a previous witness, that Larry Ray would somehow convince these students that they were poisoning him, that they were damaging his property, and basically force them to pay what he had convinced them that they owed. So according to Drury today, there were two things in her life that she identified herself with when she was under Ray's spell, being a poisoner and being a sex worker. And of the two, at the time in 2016, sex work was much better for her.
Disturbing allegations right there. Okay, Nicole, I'm going to ask you a twofold question. One, how do you think the prosecution's doing so far? And two, if they actually are able to convict Ray, what kind of penalties is he going to face?
It's, again, an incredibly serious crime, and he could be looking at many, many, many years in prison for this. And I think that the prosecution is doing a good job here of painting a picture of someone who is indeed disturbed and dangerous, in the sense that, you know, you have an adult man who moves into a college dormitory and then starts to work on manipulating the people around him. That is the picture of this defendant that the prosecution has so far been able to paint. So I think they're doing a good job.
See, so Terry, let me ask you this. If he is convicted and goes to prison, that's one part of the chapter being closed. You think about the alleged victims in this case. If he's convicted, I mean, could there be any payout to them at any point? Do they seek any kind of remuneration? What could happen there?
Well, absolutely. They should seek some sort of remuneration if, in fact, he's convicted. And even if he's not, look, they could bring a personal injury lawsuit against Ray, and they would also be able to bring, this is my favorite cause of action, intentional infliction of emotional distress. And what they have to show is that there was actual harm, either physical or emotional, and there would have to be actual damages. I think based on all of the tapes we've seen, all of the testimony so far, it's been riveting testimony. There's no question that there was actual harm to these victims, and they certainly should be able to bring a civil case. Now, they could also bring a civil suit against Sarah Lawrence, the university, and that basically would be based on the fact that they failed to provide adequate security. Why did they allow this man to live on campus? He had a prior record, Jesse. No way he should have been allowed to live on that dorm.
Something's not adding up. Yeah, I've never heard a case quite like this, and maybe that's the reason, so thankfully. Nicole, Terry, thank you so much. Everyone out there, thanks so much for joining us here on Law&Crime Daily. We'll see you next time as we discuss justice in America.